Yes. Before I note that we don't have the charge sheet. Mr. Thomas, the charge sheet is not before court. But when the court starts, the charge sheet must be in court.
Yes,
Yes.
I apologize because my colleagues are the one that are supposed to get it. I do apologize. Perhaps if I can just go and get it myself then. It's supposed to be brought before I get here and signed off by them. Miss
Yes,
Hinda.
because it's having all the
Yes,
exhibits.
I
In the
understand.
event, we refer to any. There is nothing before.
I understand, Your Worship.
Yes.
Your Worship, we can, under the circumstances, briefly stand up.
Stand down.
Yes.
Okay. Better than briefly stand.
Authorize.
We can proceed.
Mr. Court pleases, today is the 8th of August 2025 in the Magistrate's Court sitting at JP Karwahe Street in the matter between the state and Immanuel Mulunga and 14 others. Case number 854 of 2025, presiding officer, Mr. Samunzala, for the state, Mili Lungwe, for accused 1 and 3, Mr. Bangamavo, accused 2 and 14, Mr. Isaacs, accused 5, 6, 7 and 10, Mr. Namanja, accused 4, Mr. Kasper, accused 9 and 15, Ms. Gebhardt, and we are ready to proceed.
Councils, we can proceed.
Please, the court, your worship, I confirm my appearance for accused 1, 3, that is 4th and 5th applicant for purpose of this bail application, your worship. I'm ready to proceed.
Please, your worship, I confirm my appearance of accused number 2 and 14.
May it please the court, your worship, I continue appearing on behalf of accused number 4.
May it please the court, your worship, I appear for accused person number 9 in these proceedings.
As the court pleases, your worship, may I continue, your worship?
We can proceed.
Now, Mr. Inambao, if remember I asked you whether or not during your police training you were also trained on the provisions of the CPA, Criminal Procedure Act.
That's correct.
Now, have you been trained in respect of how to charge a director of a company? If you want, I'm not talking about a corporate entity to be charged, I'm talking about a director. If you want to charge a director of a company so that he is in criminal law personally liable, have you been trained in that respect?
No, your worship.
No. So, do you know that directors of company could be personally criminally liable if prosecuted in terms of section 332, subsection 5 of the Criminal Procedure Act? Do you know that?
That's correct.
Okay, it's good that you know that. So, in other words, you know that section 332, subsection 5 of the CPA is your vehicle to personally charge, prosecute, and send to prison if convicted a director of a company or a member of a CC. I see you are nodding.
Yes, that's correct.
Okay, very good. Now, as I understand your case in this matter, the case that is not yours, the case that you are investigating, the Mr. Peter Elindi and Malakia Elindi, you caused them to be arrested by virtue of the fact that they were the directors of Enercon, and what they could have done in the course of corporate activities as directors. Am I correct?
Partially.
Oh,
You are partially correct.
Okay. Which part of it is correct?
That they were directors. We know in terms of the evidence that they benefited from the money.
Yes.
Yes.
So
Is in their individual capacity as well.
okay, fine. But partially, when you, for instance, told us that they misrepresented, assuming there was a good case there, they made misrepresentation when they signed the acceptance. They were acting in their capacity as directors of Enercon. You say that.
That's correct.
So in other words, let's start. So you are saying partially it's true. It's because of their position in official capacity as directors and what they did representing Enercon, but you're also saying partially it's in individual capacity, as I understand you.
That's correct.
Okay. Now, Look at the bundle that I gave you yesterday, Your Worship, the new bundle, which had the warrant of search of Mr. Peter Elindi. Do you have that, Mr. Inambao? Yes, I think is that one. I cannot see.
The loose one or the one in the file?
Yes, I think that one. Yes, the loose one. I just want to make sure. I think I handed up a copy, Your Worship. Yes. Yeah. Okay, thanks. Mr. Inambao.
What page?
Page 1, Your Worship. After the table of content. Now, at page 1, you see that appeared to be, as I understood, the purported warrant of arrest of Mr. Peter Elindi. Am I correct? Just take your time.
That's correct.
And I see on, let me just be fair to you. Go to page 2, Your Worship, page 2. Page 2, you see the third line from the top third line refers to Peter Hango Elindi. You see that?
Yes.
And you see at the bottom, you see where the public prosecutor's signature is.
That's
you see
correct.
that? You see then somewhere down, again, Mr. Peter Hango Elindi's name is mentioned.
That's correct.
And when you go back to page 1, again his name is mentioned at the bottom of the senior public prosecutor in the magistrate court window. You see that?
Yes.
Okay. Now, do you agree with me that, in fact, the name Enercon does not appear in the charge sheet at all, in the warrant of arrest?
That's correct.
The warrant of arrest also does not refer to section 332, subsection 5 of the Criminal Procedure Act. Am I correct?
You are correct. But these were preliminary charges, meaning when the evidence was presented before the prosecution team, they decided on other charges, including the one that you are referring to.
No, it's fine. It's fine. But when you caused a warrant of arrest to be applied for, you knew partially they will be charged because of their official position as director, and partially in their individual capacity. It was open to you to inform the public prosecutor and the magistrate issuing the warrant that these people will be charged, amongst others, on the basis of their corporate activities.
Mr. Namanje, these were preliminary charges, and as you indicated, there's no way we could go and arrest Enercon. We had to arrest the individual. And
Okay. No, I'm not talking about, I think a company can be charged. Is that correct?
yes, but you cannot go and arrest it.
Yes. I'm not talking about Enercon to be arrested. I'm talking about a director to be arrested because of his position as a director of a company. I'm not talking about...
Of course.
Yes. Or I'm trying to say, in the warrant of arrest, it's not stated that Mr. Peter Elindi, director of a corporate entity, Enercon. You agree with me?
I agree with you.
Okay. Now, that is the same. I don't want to waste time. That is the same with Mr. Malakia Elindi. If you go to page 4. You see that?
Yes, it's the same, and as I said, these were preliminary charges. Meaning the state, in this regards, the prosecution team, when they were presented with the evidence, it was at their discretion as to bring as you know, they list the number of charges that they could bring based on the evidence.
Okay. And to choose in what capacity whether they are relying on section 332, subsection 5, or whether they are charging them in their personal and individual capacity. You
Yes.
left it to the
They
prosecution.
are the prosecutors that are the ones responsible for the charges.
Okay.
Yes.
No, I'm not blaming you. I just want to place facts on the record through you. Now, you also see, if you look at the warrants of the offenses referred to, if you, for instance, look at page 1, you agree with me that what appears in the warrant of arrest all over up to the next page, up to the 3rd page, nowhere is any reference to section 332 of the CPA on the charges themselves.
I've answered that question
Okay,
already.
that's fine, fine. Okay, now I want you to move to page, just because you said you were not trained on section 3, how to charge section 332. Go to page 97 of the same bundle, Your Worships. Your Worship, page 97 of the same bundle. Now, I just want to, there is something I want to ask in relation to the fraud charge against Mr. Peter Elindi and Malakia Elindi. If you can assist me, just 4 lines, just for context. You see that at that page there is a judgment called R versus Smith. You see that on top?
Yeah?
And others 1960, volume 4, SA, page 368. You see that? Judgment by Justice De Villiers. You see that on top?
I see that.
Okay. And now you see paragraph A on the left, paragraph A.
I see it.
If you move at the bottom there, then there is 430 pounds. You see that? 31 pounds.
I see it.
Okay, then it says count 2. Count 2.
I'm there.
Yeah, I just want you to read that sentence for me for context before we go to the fraud charge in this matter. Just those, starting with in that, you end with Roman 2. Just read it for me.
In that, whereas at all times relevant to this count, Roman 1,
Yes, just go on, Mr. Inambao.
Windsor Motors, Natal Pty Ltd, was a corporate body and a subsidiary of Windsor Motors Pty Ltd, carrying on business in Durban.
Yes, go on.
And then 2, accused numbers 1, 2, 3, 4, and 5 were either directors, managers, secretaries, officers, or servants of Windsor Motors.
Okay, you can end there. Let me just, are you aware of a judgment of Minister of Justice in Namibia versus Attorney General that declared that employees of companies cannot be personally prosecuted for activities of the company like directors? Are you aware of that judgment? It was a judgment in 2008 or 9. Are you aware of that judgment?
I'm not aware of the judgment, but I'm not here to translate or interpret the piece of legislation here.
I'm just asking for now. But I think you should know.
I've answered.
As a law enforcement agent, you must know. Okay, fine. Now, just keep that paragraph, that a preamble, how directors are charged for them to be personally liable in criminal law. Now, let's go to the charges against my clients to demonstrate that with respect, the state didn't begin to come close to have a good case against my client on many grounds. Now, if you go to page 17, Your Worship, page 17 of Exhibit D2, You have D2, Mr. Inambao?
Yes, I do.
Page 17, 17. Now, you remember you said you applied for cause warrant of arrest to be applied for, and you said you left it to the public prosecutor to make an election whether to rely on section 332(5) and so forth. It's not your duty. I accept. You said that.
Mr. Namanje, I said the charges on the warrants of arrest were preliminary charges.
Yes, yes, yes.
Evidence was presented to the prosecutors upon which, even, subsequent charges were inserted, including the charge that you are referring to.
Okay, that's fine. You see at page 17, there's the count. That count is the first. I just want to look at the first fraud charge, your worship against. Yes. So, excuse me. Pardon me, your worship. It's actually we started page 14. I do apologize for that. Page 14. Yeah, Mr. Inambao, you see that those are the charges against Peter Elindi.
That's correct.
They started count 34.
That's right.
Count 34 is fraud against him.
Yes.
And I do not want to waste time. We went over that. That is a charge that is alleging that on the 15th of July 2022, he, and I'm saying he personally, individually, because it says in B, that he was to sell the 9 service station to NAMCOR, and he was not in a position to do so. So it goes on. You see that?
I see that.
Now, the first observation is that if you look at the charge, it ends, there is absolutely no reference to section 332, subsection 5 of the CPA. Do you agree with me? At all.
Although there is no reference, these are, I believe, your clients has not been asked to plead to the charges as far as I'm concerned, Your Worship. These are preliminary charges which the state had to. Are
you giving advice? Or I'm trying to say, I make an observation. There is no reference to section 332, subsection 5, sir.
Yeah, it's not there.
Okay. This charge is targeted at my client in personal and individual capacity, not as a director of Enercon. Any comment? Only if you have.
Fraud happened, misrepresentation was done.
Yes.
NAMCOR had suffered an actual loss in this regard. And the pieces of documentations that was used were simply instruments. The contract, the agreement, was simply an instrument to get the money out of NAMCOR.
Sir, all I'm saying is, do you agree with me that he's charged in personal capacity?
That's right.
Okay, good. There goes the state case. Now, just while we are there, you see at B, yesterday we went through the asset purchase agreement. I would want to put it to you while we are there, that in that agreement you will never find a phrase, service stations. Do you agree with me?
Yes, but service station is probably just a word. As I was saying, these charges, the state would still have time to revise these charges, and you can still argue that with the state at the end of the day.
Yeah, but we are arguing today, not in future. And my client, their lawyers, will argue on what is before the court. Okay, do you know the reason why a new phrase which is inconsistent with the agreement was used?
I can't say as to why that was the case.
Okay, let's move on. Next page, page 15, Your Worship. That is the alternative. Again, there is no reference to the word director does not apply. It does not appear in that charge. In fact, the name Enercon does not appear. And section 332 subsection 5 does not appear. Do you agree with me?
I agree with you, and I'm sure it's just an omission that was made, and the charges would still be revised.
It's a fatal omission for purposes of this bail application. That's what I want to suggest to you. Let's go on at count 35. Again, same thing. I have already gone. That is being charged in individual and personal capacity. The state chose and elected not to rely on section 332 subsection 5. Am I correct?
Mr. Namanje, I want to remind you again that I am an investigating officer. I gather evidence and I present the evidence to the prosecutors.
Okay.
It is the duty of the prosecutors to make sure that, the charges are correct.
Okay. No, it's fine. All I'm trying to is because you said you have a strong case. All I'm trying to say is through you to demonstrate you don't have. Let's go to count 36.
Do you have any comment there? But he's trying to demonstrate you don't have a strong charge.
Your Worship, the evidence has demonstrated there is a strong case.
Okay.
Offenses happened. Misrepresentation was done to NAMCOR. Subsequent to that, money was paid. Thereafter, bribes were even paid to staff members, Your Worship. So therefore, there is a strong case.
Okay, no, it's fine. We have gone over that. I am now showing from another angle. I have already showed you from several angles how the state case is weak, but I'm showing you from another angle. Okay, so count 36 for completeness. I will not deal with Mr. Malakia Elindi because it's the same. In the interest of time, again, there is no reference to section 332.5. You agree with me?
Yes, I hear you.
Yes. The same is with count 37. Do you agree with me?
I hear you. But not that I agree with you, because I've always maintained that, the state, these are preliminary charges.
Okay. But are you relying on the preliminary charges? Are you relying on them?
Given the amount of time that the state had to come up with this at the time they were coming up with this, I do.
So you are working with, your answer is that, yes, they are preliminary charges, they are not, but given the time, that's what I have to work with. I pity you, but let's move on. You laid your bed, you must lay in that bed. You rushed into this arrest. You pushed us in these circumstances, and you pushed yourself in those circumstances. But let's go to count 38 at page 16. Just one comment. Again, it continues. The state elected that is personal capacity. Section 332 is not referred to. Do you agree with me?
I agree with you, but remember that it's not only in their capacity as directors, but also in their personal capacity.
Yeah, but that's what I'm saying.
Yes.
Here, this one is personal, individual. And now, and this is how election in law works. If you made a procedural election, you are bound by the choice you made. Look at count 39. look carefully, take your time. Do you see section 332 subsection 5? Look in the heading there. Take your time.
Yes, it's there.
Yes. That one the state elected and choose that there they will do the right thing if they want to charge a director of a company. So I want to put it to you that it appears the state actually had time to make a choice if they wanted, because count 39, they made the choice that, yes, these people are directors of Enercon. The only way we can charge them to get them convicted personally is to rely on section 332 subsection 5. Do you know why the state chose, in respect of fraud and other charges, it is individual capacity, which is wrong, will prove fatal. But in one count, the state relies on section 332 subsection 5.
I've already answered Mr. Namanje,
Okay.
so
Again, you see in the alternative count, that alternative to count 39, again 332.5, the state chose to rely on that section of the CPA. There I'm not blaming them, but it doesn't assist them, I will argue. But let's then complete over the page. Page 17, Your Worship. Now, that is the second count 40. That is the charge, apparently, that breach of contract, where the state is relying on the contract. You are saying it was an instrument, unlawful instrument. That is where the state is relying on the same contract, saying you breached it. But anyway, you see that that fraud, the state skipped 332 subsection 5, which it used in count 39. So in other words, the state reverted back to individual capacity as if my clients were not directors. You see that?
yes, I see that.
That's very, very dangerous.
But Mr. Namanje, as I've been saying, there are preliminary charges.
Yes, fine.
Yes,
fine.
there are preliminary charges, so meaning the state would still have an opportunity to.
Okay. But so they say in our village, they say you serve your best wine first. So this is the best wine the state has in terms of the charges. That is the logic I'm trying to, for purposes of bail today.
Yes, in terms of the evidence, there is evidence to prove
Okay.
the offences had happened, and we have gathered that evidence.
Now, with that said, I put it to you, sir, there are several problems with this case. And when I argue on Monday or Tuesday, at the end of this bail application, I will demonstrate that. Do you have comment? Only if you have a comment.
From your point of view, it's within your rights to argue whatever that you are going to argue.
Okay.
As far as the evidence that we have gathered is concerned, we have no doubt that the offences that are in the charge sheet were indeed committed.
No, it's fine, Mr. Inambao. I want to end with a very important matter. You are doing a public duty, and it's a noble one, and all of us respect it. Do you have any comment?
Public duty must be undertaken. We investigate offences where crimes has happened,
Yes.
and the due process needs to be undertaken, including securing the attendance of the accused persons to court.
Yes.
In order for that process to come to an end.
Yes, we are on the same page. And notwithstanding the fact that you have a constitutional and statutory duty to effectively and fearlessly combat crime, including corruption, as you are saying, the due process, which is fair and varied process, must be followed. Is that correct?
Yes, and that process was followed.
There is no contradiction. There is no contradiction between you doing your work effectively, as expected, in the interest of society, and you complying with the Constitution that you must be fair and you must follow the law relating to arrest, detention, and bail application. There is no contradiction.
Every law that you are referring to has been followed.
Yeah, okay.
And that is why we are here, is because you are exercising those rights.
And our founding fathers, those who drafted our constitutions, says these men and women in the dock, while their liberty could be taken away in accordance with the procedures set out in an act of parliament, they remain human beings with dignity and with rights which must be protected and respected by everybody, including ACC and the police. Do you agree with me?
I agree with you. That is why we are here in court. That is why they are here. That's why investigations was conducted.
Okay.
They were apprehended. They were brought to court. They are exercising their right to bail. You know, the Constitution does provide circumstances under which these rights can be limited.
Okay. The fact that they are being accused of corruption does not make them bad suspect than a suspect in rape, in murder, or a suspect who stole boerewors.
A suspect is a suspect.
A suspect
Provided
is-
the law has been broken,
Yes.
that person has to be dealt with in terms of that specific law.
So all these suspects, irrespective of the offense, including high treason, they are entitled to lawyers of their choice. You agree with me?
That is why you are here, Mr. Namanga.
Yes. And in fact, you and me, we are servants of the people. You do it in public service, I do it in private. The court has an independent and impartial function in criminal proceedings so that there is justice both for the society and for the accused person. Do you agree with me?
That's correct.
So in other words, we are all part of the system fixed by our founding fathers who chose that people, notwithstanding charges pending, their rights must be protected. You can't start because they are accused of corruption, you treat them differently from people accused of stealing tires.
I don't see that they were treated any different from anyone. In fact, the rights of the accused persons has been the same with all the other accused persons.
Including presumption of innocence.
They are innocent. They are not guilty.
Yes, and it's not a symbolic, it's not a dead letter. That provision under Article 12 of our Constitution is not a dead letter. It's substantive. It must be practical. It must be beneficial. Do you agree with me?
Of course.
It's not just there to window dress it.
Of course.
Okay. And now you spoke about an address of, if I understood you, of, is it eco trading? That you suggested that an address belongs to accused number, Mr. Elindi. Please correct me if I'm wrong.
You are
When
right.
my colleague gave you documents to read from BIPA, I think.
No, I didn't read it from the documents.
Where did you read it from?
During the investigations, we had access to the documents that the state is in possession of.
Yes.
Yes.
I just wonder.
No, from the founding
founding
state.
statement of eco trading, is it?
Eco trading and
Okay.
eco fuel investment.
Okay, so Mr. Elindi testified in this court that he has nothing to do the establishment or operations of Eco Trading. It's not his company, and he has nothing to do with it. He does not. It's an independent company, has nothing to do with it. Do you have any comment about that?
Well, that's what he said in evidence.
Yes, yes.
But in terms of the evidence that we gathered,
Yeah.
there is relations in terms of the address, for example, indicating that the owners of EcoFuel and Eco Trading are related to Mr.
Okay,
Peter.
no. I think you don't understand. I will come to that. I said in terms of management, establishment, in other words, the company who ran Eco Trading, he has nothing to do with.
Yeah, his name is not there.
Okay, very good. And he also testified that the owner of that company, the beneficial owner, you testified, at one point, he raised him in his house, but then left. And I think he even said that they currently do not have a relationship. Do you disagree with that?
Oh, well, a relationship is not something that you can just cut off.
Oh.
And I'm saying so because despite Mr. Elindi, Peter Elindi, saying that he does not have a relationship with Simaneka, when he left Enercon, Mr. Austin Elindi and Simaneka became partners. So they're still tied by bonds because you don't just cut off a relationship.
Who
Mr.
became partner of who?
No, I'm saying shareholders in Enercon.
Yes, exactly.
So they're still bound by family ties. Even if they're having a disagreement, they're still bound by family ties.
Yes, just like everybody of us.
Yes.
We have some people who I could say are involved in criminal activities, but we remain bound by them. But I'm not saying the owner of Enercon or Eco Trading are involved in criminal activity. We remain bound by them, but that does not make us criminals.
Yeah, and I didn't use the word criminal.
Okay, no.
I just said that they're bound by the ties that they have established.
In fact, Mr. Elindi doesn't know how and why his address was used. It's the first time he found out in court.
I'm hearing that from you.
Okay, so it's nothing you can hold up and say you have a strong case. It's nothing really, basically. It's nothing.
But as far as I'm concerned, there was no charge relating to Mr. Simaneka using the address
Okay.
of
Then
Mr. Peter Elindi.
Then it's irrelevant. Sorry. Then it's irrelevant.
Then we can move on.
Yes. Your Worship, the next time you hear me. Oh. Yeah, Your Worship, may I ask that just one last question. Look at the bundle. I almost forgot about this. Mr. Inambao, have you heard about a company called Petroneft that was in a relationship with NAMCOR some years ago?
What name?
Petroneft.
No.
And Glencore.
I've heard Glencore, but not the other one.
Okay. Now, I want to ask if you look at the... Your Worship, do you have... Yes, it's in this bundle. Mr. Nyambali, if you can just take this bundle.
Which bundle?
The regulations, Your Honor. Give to the witness. Now, remember I told you that me and you both do a public. I do it in public, you do it in... Now, there is a judgment of Minister of Mines and Energy versus Petroneft. If you go to page 81, Your Worship, that Supreme Court judgment, you see that at page 81?
I'm at page 81.
Yes, to page 97. Now, you see, I just want you to ask, you say you have heard about Glencore.
Yes.
Now, I want to just advise you, it was a party, and you see that I actually represented the Minister of Mines those years in that matter. Now, you see that in that matter, if you go to page 95, paragraph 47, the judgment, I will refer to it in argument, but I just want your comment on one specific thing. You would see, if you look at that cabinet resolution that is quoted in paragraph 47, it's about government bailing out NAMCOR because of the debt left by that bad agreement with Glencore and Petronet. In other words, government was, in fact, it was a monthly thing where NAMCOR entered in a very bad agreement now. In the context of this, I want to just put it to you, it appears there can be, in running state corporation, of course there can be corruption, but there can also be cases where mistakes are done because of negligence, because of incompetence, or bad judgments. Do you agree with me?
I hear you.
And if a bad deal, happened, and government suffers, it doesn't necessarily and immediately translate in a criminal offense. It may be a civil wrong. In some cases, of course, if you establish fraud, corruption, or whatever, good. But the law does leave space for civil wrong in corporate, because those decisions, Namibia, wherever, SME, you can make mistake in taking decisions. Do you agree with me?
I agree with you, but it's not the same as in this case.
Okay.
We have demonstrated in terms of evidence that, after this money was paid to Enercon, this money was distributed further, which culminated into kickbacks and gratifications that were paid, even among others, including staff members.
Okay,
so it changes the dynamics.
Okay.
So because of that criminal culpability or that component of the people the very people who were actually supposed to be protecting those assets ended up receiving that money.
Yeah, but you remember that I have already demonstrated that if there was payment of bribes, my clients were not involved. That debate, but you now just said something I always wanted you to say, which is, it was the alleged payment of bribe that changed the dynamic from a good deal to the bad deal. And that kills your case unless you prove bribe against my clients. That's my last statement to you. You just broke up the state case.
You want me to comment?
If you want.
Comment, if you have any.
Otherwise, I will argue it, only if you want.
Yes.
Your Worship, the evidence was laid down. It showed how the funds were distributed. That's my last comment, Your Worship.
But the dynamics,
Argument, so we can move on.
as the court says.
Yes.
Next time you hear me, Your Worship, it will be when we do our final legal submissions on Monday.
It's in order.
Please, the court, Your Worship. Your Worship.
Whether we take a short break while you are organizing, short health break?
That's in order,
Yes.
Your Worship.
The court will take a 10-minute health break.
Your Worship, I just rose to mark the two exhibits. The bundle, not the one with regulations, Your Worship, the bundle that had the warrant of apprehension should be, I understand, is H. Next, H.
Exhibit H.
Yes.
If it can be marked Exhibit H. H1. My colleagues are suggesting H1, Your Worship. Yeah. And then the Petroleum Products and Energy Act regulations be H2. Yes. If there are no objections.
Any objections?
There is no objection, Your Worship.
No objection, Your Worship.
As the court pleases.
Just for the record, Mr. Namanja, the first exhibit, Exhibit 8, goes up to 215 pages. Can we just...
H1, Your Worship,
Yes.
you are talking about
H1.
215.
215 pages.
And the other one, up to 97. 1 to 97.
Mr. Namanja, I want to put a name to
Yeah.
Exhibit H1.
Yes,
I see it's the index.
Yeah, I think the best index, yeah, it's paginated, you can call it a paginated bundle, including two warrant of apprehensions. I think that way. It has other documents, but I think because it's already paginated and the content is self-explanatory, Your Worship. Yes.
Then the paginated index bundle is marked as Exhibit H1, running up to 215 pages. Exhibit H2 is the Petroleum Products and Energy Act 13 of 1990.
Regulations.
Yes.
Yes, that's the court. Together with the judgment, Minister of Mines and Energy versus Petroneft International, Your Worship.
Yes, because it runs up to 97 pages.
As the court pleases.
Yes, we can proceed.
As the court pleases.
Please, the court, Your Worship. It's now my turn as the counsel for first and third accused person. That is the applicant, fourth applicant and the fifth applicant, to cross-examine the investigation officer. Good morning, Mr. Inambao.
Good morning.
Are you well?
I'm fantastic, thank you.
Excellent. Yeah, Your Worship, I will not be long. A reason being that Mr. Namanje has covered most of the items or the issues which addresses the issues, and more importantly on the merit or otherwise of the charges against all the accused person or applicants Of course, he has done a good job, not only for his clients, but also for the court as an officer of this honorable court. So I'm not going to belabor the court by repeating what has been said. I will simply try to amplify on one or two things. I will firstly deal, Your Worship, in this cross-examination. I will be referring His Worship to Exhibit E1. E1 being the list of authorities which were used when I made opening statement. E1, and then E2, that is the bundle containing all the documents relating to fourth and the fifth applicant, then more importantly to the charge sheet and the annexures thereto, and then D1 and D2. That is in the bundle for first and second applicant, Your Worship.
As you please, you can proceed.
Please, the court, Your Worship. Mr. Inambao, I hope the state, I hope he has got all those documents I referred to. Yeah, so.
Do you have exhibit E1 and E2?
I have the exhibit marked D2. These other two, I believe, that the ones Mr. Namanje just handed in.
Yeah, those one have been marked, so this one.
If the witness can be given those two exhibits, E1 and E2. More importantly, E2, Your Worship. Well, that is the bundle for fourth and fifth applicant. Yeah, so Mr. Inambao, like my colleague informed you this morning, and since yesterday, you are a witness not only for the person who called you, for the state, but very important, you have a duty to the court, because the court will have to rely on your evidence in order to make an informed decision. Are we together?
We are together.
Thank you. Now, when you testified, you said you have no legal qualification, but of course, if you look at the present matter, we are dealing with the very complex matter, dealing with the legal issues. If I might ask, do you have a lawyer or a legal department within ACC?
Your Worship, as far as I am concerned, we are looking at offences in terms of the Anti-Corruption Commission, the Anti-Corruption Act, fraud and money laundering. As to whether the Commission has a lawyer, the PG's office provide those services, because when we investigate, if there are issues, we bring them to the prosecutors. There are legal people who can advise on certain issues and so forth and so on.
Very good. Now, if you are investigating, like in this matter, and you are stuck on legal issues, you are telling the court you always approach the PG's office for legal guidance. Is that what you are saying?
Of course.
Can you speak up?
Of course.
Thank you. Let's start with the, you told the court yesterday and today that actually you have no problem with the fuel supply agreement, that is the agreement of 16 March 2022, and the asset purchase agreement which was signed or which came into existence on the 18th of July 2022. The only problem you have is what occurred later on. Am I correct?
No.
Why are you saying I'm not correct?
I said the agreements were instruments that were used in order to commit crimes or in order to get the money out of NAMCOR trading.
Mr. Nambao, I said you have a duty to the court to tell the truth and only the truth, and you are under oath. And if you lie under oath, it can attract prosecution for perjury. You know that?
I conducted the investigations.
No.
I'm
asking
answering your question. I conducted the investigations. I obtained evidence. I've testified before this court in which I said the asset purchase agreement was the instrument that was used in order to get the money out of NAMCOR, which resulted in the offenses that has been brought against the accused persons. And as far as the agreement of the 16th of March, we are talking about the conspiracy and so forth and so on. That is why we have those charges. So I'm not changing. I'm aware of my position, and I'm here to tell the truth as based on the evidence.
You did not answer the asked question. Your Worship, I asked you, do you know if you lie, you are liable, or you may be liable to be prosecuted for perjury?
Of course.
Thank you. Yesterday and this morning, you said the two contracts were legitimately signed and concluded. Do you remember that? The record will show that you told the court that the asset purchase agreement of July 2022 and the fuel supply agreement of March 2022 were legitimately concluded. Do you remember?
No. And I've already answered the question. I said there are charges of conspiracy. It looks like you are not happy with my response. So.
No, before you go there, let's go to the...
Can you just let him finish?
Yes, Your Worship. I'm listening to him.
Okay.
Yes. Your Worship, there are charges of conspiracy, and conspiracy could have, it would have occurred even before the agreements were signed. We have demonstrated in terms of evidence as to when the relationship of NAMCOR Trading and Enercon started. In this regards, it started in 2021, October. When the contracts were signed, petroleum products were supplied to which the money was not being received. Subsequent to that, asset purchase agreement was entered into. So I'm not changing anything.
Are you saying now conspiracy started before? You are now going back to 2021. Is what you are telling the court now?
Your Worship, at the time the documents were signed, it means there were already engagements. But as far as the evidence indicates, it shows that these agreements were signed in 2022. But of course, there were engagements already, and hence we started with our evidence as far as we could, and that was from 26 October 2021.
Okay. Yeah, here we go. I think there is a big problem. If you look at the charge sheet, do you have a copy of the charge sheet? The period of investigation is May 2022. Go back to the charge sheet. It's you who instructed the state to draft those charge sheets. You don't mention 2021. Am I correct?
As I indicated, as far as the records are concerned, the actual contract was signed in March. So of course that is the date, because we don't have the dates of the other engagements that would have happened. So that is why even on the charge sheets, it's saying between this period and this period. But there's no way a contract would have just been signed without an engagement. Hence we are saying, if we look at all the variables that are connected, that the conspiracy could even have started earlier, much, much earlier.
Yeah. We go to page 51, Your Worship.
Of what exhibit?
Exhibit E2. Are you there, Mr. Inambao?
I'm there.
That is the asset purchase agreement, Your Worship. going from 51, Your Worship, up to 66. No, up to 60. Yeah, it goes up to 66 because it has an annexure there too. Now, are we together, Mr. Nambawo?
I'm there.
Yeah, you know, my colleagues spend a lot of time on this agreement. Other witnesses spend a lot of time on this agreement. I'm not going to waste my the Honorable Court's time on this agreement. I just have 1 or 2 questions on this agreement. Before we go there, what is the do you have a problem with this contract, this asset purchase agreement? And if you don't have, you say you don't have. If you have, you tell the court, what is your problem with this contract? You say it was an enabler or an instrument to commit crime. Why do you say so?
I've indicated in my examination in chief that NAMCOR had bought assets which, in terms of the agreement between Enercon and NDF, those assets would become assets of NDF at the end of the agreement. Money was paid by NAMCOR as a result thereof, to which that same money was paid, was laundered and paid as gratification to staff
So
members.
that is your problem. That the money which was paid in terms of this agreement was then laundered or paid to some other people. That is your problem.
The agreement was the enabler. The agreement was the one which legitimatized the payment of money from NAMCOR. Without this document, the money would not have been paid.
Yes, Your Worship. You see, Nambao, you have a big problem. Have you heard of freedom of trade or freedom of contract?
Your Worship, as far as I'm concerned, I am concerned with the criminal investigation of offenses in terms of the fraud, money laundering, and corruption.
You are not answering the question. Have you heard of freedom of trade or freedom of contract?
I have heard about it.
Yes. Just to assist you, Mr. Nambao, in terms of the laws of this country, and in any modern society, matured people, juristic entities with the contractual capacity, as of right, can conclude agreement with anyone without any limitation. Do you agree with me or not?
You are right, provided there is no element of misrepresentation and actual prejudice on another party. And that is where now the offenses now comes in.
Okay? You agree with me on the freedom of trade.
That's correct.
And also, once parties meet, they negotiate, and they conclude the contract, no one, including the mighty ACC, no one can interfere with that contract unless the court declares that contract unlawful or against public policy. Do you agree with me?
I don't agree with you, because...
Do you understand what I just said?
I understand what you say.
Yes.
Provided there are criminal elements, we are looking at it from the criminal side of things. The civil element of things is what can be adjudicated there in the High Court, as far as the contract is concerned. But in this regards, we know that this was an enabler, which resulted in the money being paid from NAMCOR, and subsequent to that, this money was laundered through various entities, and money ended up in the staff members' accounts.
when you look at this contract from 51, because you saw this contract when you were investigating, am I right? You saw this contract.
That's correct.
Is there any clause which refers to people being paid the bribes? Is there any clause in terms of which people accepted gratification, or in terms of which after receiving the purchase price, people will be paid? Is there any such clause in this contract?
And hence we are talking about misrepresentation.
Okay.
Because we know, although that was not part of the agreement, the moment the money was paid, it was disbursed to other entities, including...
I'm coming back there. Don't rush.
Sure.
Okay? Now, you keep on saying misrepresentation. Who misrepresented who?
NAMCOR in this regard suffered an actual loss. And remember, this case was reported by...
No, I said who misrepresented who, you worship. We are not talking about the loss.
Who misrepresented?
Yes. Who committed the misrepresentation?
I answered yes. Okay. Both the directors of Enercon and Mr. Mulunga.
Who are the directors of Enercon?
Mr. Malakia and Peter Elindi.
Mr. Malakia and Peter and Malakia, they committed misrepresentation vis-a-vis, or to whom did they misrepresent? You can't just misrepresent in the thin air. A statement must be made which is false, and the person who is must act upon that misrepresentation.
NAMCOR Trading suffered an actual loss. So we are saying that this was an organized and planned crime. And hence the instrument was designed in order to enable the money to be paid by NAMCOR Trading.
I think that song is now becoming too much. I asked who committed the misrepresentation and who was victim of that misrepresentation, Mr. Inambao.
I've answered your question.
No, you did not. Maybe you answered it to Namanje, but I want an answer.
I've just answered the question.
Okay, you said there was a misrepresentation. That's the problem you have with this contract. Then I said, Inambao, for us to move on, who made the false representation to who?
Testified on record, both the directors of Enercon, that is the first and second applicant, as well as the fourth applicant.
Thank you, Worship. Now, in this regard, who is the victim of misrepresentation?
NAMCOR Trading.
NAMCOR
That is
Trading.
why...
No, you have answered. You don't need to say
No, I need to quantify it. Yes, I need to quantify it. That
the
is
victim
why
is it?
is NAMCOR.
Yeah, yes.
NAMCOR Trading.
Very
That is
good.
why NAMCOR, through its delegated board member, launched a criminal complaint.
Okay, very good. At the time this contract was negotiated and concluded, who was representing NAMCOR Trading?
Mr. Mulunga.
So you are saying that Mr. Mulunga was a victim of misrepresentation committed by Enercon directors.
Because of his involvement in the conspiracy, that is why he's here as a suspect, because he himself made a misrepresentation to his employer.
Oh, I see. Okay, we are going there. So you are saying the directors of Enercon committed the misrepresentation to Mr. Mulunga representing NAMCOR Trading. And then, because later on he conspired, that's why he's also arrested.
If there is conspiracy, it means the document was planned by all the parties. So there was an agreement, we will do this, and as a result thereof, the agreement was signed in order to make it seem like a legitimate transaction was concluded. And hence the accused persons are facing charges of conspiracy and fraud in this regard.
You see, Mr. Inambao, that's what I said. This is not an easy case because you are confusing things, because I never heard anywhere in this world where you are a victim of theft and you are arrested together with the thief. That's exactly what you are telling the court. You say the directors of Enercon committed misrepresentation towards NAMCOR Trading, represented by Mr. Mulunga. And Mulunga, obviously, according to your statement, is a victim, is at the receiving end of misrepresentation. Why is Mulunga sitting next to the people who committed misrepresentation?
Before you answer, you asked him, just correct me, counsel, if I'm wrong, who is the victim? And he responded, NAMCOR Trading. That is why NAMCOR, through the board, lodged a complaint.
Yes.
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 But your question, if I understand, you are saying the victim, according to him, was Mr. Mulunga.
Yes. Because you see, Your Worship, we all know that juristic entities, they can't just act in the abstract. They are always represented. In this instance, NAMCOR Trading is very clear. At that time, it was represented by Mr. Mulunga.
Okay,
Please, the court, Your Worship.
if that is the point from which you are taking it, say, do you understand?
Please, the court, Your Worship.
May you repeat the question?
I said Mr. Peter Elindi and Malakia Elindi, representing Enercon, according to testimony, they misrepresented NAMCOR, NAMCOR being represented by Mr. Mulunga. And now I say, in that context, Mr. Mulunga was a victim of misrepresentation. Do you agree with me?
Not entirely correct, because Mr. Mulunga made also a misrepresentation to NAMCOR Trading, his employer, or NAMCOR itself. Okay. Hence, he's also being charged together with the others, because the misrepresentation and the actual prejudice was suffered by Mr. Mulunga's employer.
You see, there is something we need to agree. We are still here. If you look at it, go on page 51.
I'm there.
You are there. You can see NAMCOR Petroleum Trading and Distribution Pty Limited. Are you there?
I'm there.
A company so and so. And then the last one, duly authorized there too. Are we together?
I'm there.
When you say Mr. Mulunga misrepresented its employees, are you saying he was not authorized to represent NAMCOR Trading to sign this contract?
Being authorized is one thing.
Yes.
But this is not the first case where people are stealing from their employer. And hence we are saying that this document was an instrument that was used in order to get the funds out of NAMCOR.
We will not get anywhere. I asked, are you saying Mr. Mulunga, as a managing director, was not duly authorized? No. Yes or no?
He had the authority.
Yes.
By virtue of his appointment as the managing director of NAMCOR,
yes,
he had authority to enter into agreements.
Yes.
But in this regards, we are saying the agreement that was entered into was an instrument that was used to get money, fraudulently get money out of NAMCOR.
We go to that later. I'm still here. You agree with me that he had authority to negotiate and sign this contract?
Yes.
Thank you. Now, you know one of the charges against Mr. Mulunga is that he pretended to NAMCOR. You don't say which NAMCOR. We are coming to that. You don't say whether it's a National Petroleum Company or whether it's a NAMCOR Trading and Distribution Pty Limited. But while we are still here, you confirm to the court that indeed he had authority. Why did you charge him of pretending or misrepresenting the board that he did not have authority, Mr. Inambao? After you confirm on record that yes, he had authority, yet you went ahead, you arrested Mr. Mulunga for not having authority, that he misled the board, he acted without the board authorization. Why did you arrest Mr. Mulunga?
Although he had authorization by virtue of his position, there were certain processes and procedures which needed to be followed before he could enter into a contract,
Okay?
which he didn't do, and hence the charge maybe reads as pretended, because there is policies in place that he should have followed. There is budget in place that he should have ensured it was followed, but all that was not followed.
Okay.
As a result thereof, NAMCOR ended up procuring assets which they actually did not enjoy the benefit of.
Yeah, number one, you have a problem. I will tell you your problem. Because you are mixing up fighting corruption, you are mixing up disciplinary misconduct for not compliance with the internal policy, you are mixing up breach of contract and remedies. I don't know how you are going to get out of that this mess. But let's carry on. You say Mr. Mulunga was arrested because he did not comply with some internal policies. Am I right?
Of course.
Now, is there any law in this country? In this country, is there any law which calls or which invokes criminal liability and prosecution for not complying with the internal policies of any given company?
Non-compliance to policies was simply some of the circumstances which resulted into the actual offenses. Because remember, when we are talking about the contract, as an instrument, it resulted into the money being funded from NAMCOR, paid out to Enercon. Subsequent to that, it was distributed, it was laundered, paid to other people, and so forth and so on.
Your worship, yeah, your worship, your narrative will not help you. I said you investigated this matter, you went through all the policies of NAMCOR. Are we together?
Yeah.
Can you name one policy which was not followed by Mulunga? Which policy calls for criminal prosecution and arrest if Mulunga does not comply with that policy?
Yes.
One, name one.
Non-compliance to policies alone does not amount to a criminal conduct.
Thank you so much.
However, when the instrument was crafted in order to get the money out of NAMCOR fraudulently, and then the money subsequent to that, it was paid, of which some of the money ended up in the staff members' accounts, that in itself is an offense, and this instrument was simply created in order to make the transactions on the side of NAMCOR look legitimate.
Okay? Now, you say non-compliance on its own does not call for criminal prosecution. I heard you correctly?
Yes.
When you look at the schedule of authority, you saw it when you were investigating this matter.
That's correct.
A NAMCOR schedule of authority. I think it's clause 40, your worship, of that authority. I don't want to waste the court's time. That clause gives the power to the managing director, that is Mr. Mulunga at that time, to sign any contract, irrespective of any amount, without any board approval. Do you agree with me?
Entering into a contract, it's one thing, but procedures should have been followed before the actual entry into the contract. Meaning they should have, the internal processes should have been satisfied. They should have been budget. The financial procedures should have been complied with. Procurement process should have been complied with before finally entering into a contract. Mr. Mulunga could have entered into a contract even for 500 million.
Yes.
That was within his rights.
Yes.
In terms of his capacity.
But
it's the
clause 4.2.
Yes, but the method in how he entered this contract is the one which is questionable.
Okay. Now, to assist you and to assist the court, so that we are reading from the same page, I asked, can you name one policy or one regulation which Mr. Mulunga, as the managing director, at the time of concluding this contract or negotiating, one which was not complied with? One, and then we move on. If you don't know, if you don't remember, you are free to, because you are a human being, you are not a robot, you may not
Can you just repeat the question again?
I say, for us to move on, you say Mr. Mulunga, he had authority to sign any contract, including
right.
500 million.
That's right.
But the process, the way he did it, he did not comply with internal policies. And then I asked, can you, for the benefit of the court, can you name one of those policies which were not complied with by Mr. Mulunga?
The financial policies and procedures is one of them.
Okay. Which clause of that policy?
I'm not having the policy in front of me for me now to say which clause is it. You have been kind to be referring to the clauses as when you started.
You see, Mr. Inambao, you have a problem because you are the chief investigator in this matter, and you collected all the documents, after which you charged and arrested our client. You can't just say you violated the law. You must be able to say you violated Article 10, or you violated the Regulation 5.
We are not saying that we charged Mr. Mulunga simply because he violated a policy. Mr. Mulunga has been charged because his conduct amounted to a criminal activity. And the policies that were not followed is just circumstantial evidence which indicates that this should have been followed, but he didn't follow it.
Okay, Your Worship. You see, Article 12 of the Constitution says that, among other things, says that no one may be charged and prosecuted for a crime, for a conduct which was not specifically laid down in a law prior to that conduct. Do you understand what I said?
I understand what you say.
Okay.
The law in this regards, the Anti-Corruption Act, and as well as the money laundering and the common law fraud, makes it a criminal offense.
Yes.
So there is laws, and that is why they have been charged criminally, because elements in this regards has been proven that their conduct amounted to a criminal.
Okay. Yeah, which is Mulunga guilty of any crime? Did he commit any? Was he found guilty of any crime?
I don't know whether I must really answer this question. We are here because Mr. Mulunga was arrested and is being charged for the offenses. As to whether he's guilty or not, that is a determination which will be made by the court after the evidence has been laid during the trial.
Yeah.
But for now, he's facing the charges, and we are saying there is evidence he committed offenses.
Yeah, in about we have let's park the issue of the contract. When you went through this contract, the asset purchase agreement, you confirmed to the court. I don't want to belabor the court. The parties, Enercon, represented by first and second applicant, and NAMCOR Trading, represented by the fourth applicant, they sat, negotiated, they agreed, number one, Your Worship, on the subject matter of the sale. Subject meaning titles, rights, and the interest in the storage facilities. I don't want to go back there. That was agreed upon. Number two, all representatives of both entities agreed on the purchase price, 53 million something. Are we together?
We are together.
They agreed, number 3, on how the purchase price shall be paid. Are we together?
We are together.
And then they agreed how and when the buyer, that is NAMCOR, will take delivery or possession of the subject matter of the sale. Are we together?
We are together.
Yes. So, all in all, the parties to the contract were at Edem, the meeting of minds. They agreed on everything, and the contracts become valid. And I will argue to the court that this binding contract does not violate the law, there was no misrepresentation, and the concluding thereof cannot constitute a crime for which Mr. Mulunga has been arrested. Do you have a comment?
The same assets. Enercon had an agreement which was still in force with the Ministry of Defense. In respect of the same assets to which Enercon had an agreement with the Ministry of Defense, is the same assets which they sold to NAMCOR. Hence, the misrepresentation.
I'm not going back to the issue of misrepresentation because you end up confusing everyone, confusing yourself.
You can move on.
Please, the court, your worship. Now, I give you a simple scenario. I come to you, I want to buy a car. We sign, you show me, Francois, I'm selling you this car. It's a Toyota Corolla. We sign, I pay you the money. After paying the money, you don't bring me the car. Or you misrepresent to me that, Toyota Corolla, it turns out to be a Mazda. Will I be arrested for that? Because you misrepresented about the mark or the model of the car? Do you go to court, to the ACC, to be arrested for that? If you have a comment, you can make. If you don't have a comment, we move on.
There's still misrepresentation. There's still misrepresentation. If you are buying a car from me, I'm not sure whether the scenario you are giving me would be, equal to what we are here for. But if I make any misrepresentation to you, I have committed an offense.
You see?
If I promise to deliver a car to you and I didn't deliver it,
Yes.
equally I've omitted the offense.
Yes.
If I've promised to sell you a Corolla,
Which offense is that? Tell the court.
Yeah, finish
Yeah,
his
let it,
answer.
yeah. Apology, Your Worship.
Yeah.
Please, the court, Your Worship. You can carry on, Mr. Number 1.
so if I have promised to deliver a Toyota Corolla to you and I'm bringing to you a Mazda, equally still an offense. I've made a misrepresentation to you. That was not the agreement.
Mr. Inambao, I will argue to this court that you definitely have killed the state case, because in terms of the law, when you worship, when both parties to a contract, one of them does not perform as per the contract, then the innocent party, the aggrieved party, has the right to approach the civil court in order to seek remedies which can be cancellation and restitution or specific performance. That is my argument. Do you have any comment?
Maybe before I go to the
Do you have any
comment,
comment?
Your Worship,
I did not. I just want to comment on my question.
I will comment.
No, I don't want to go anywhere because I want to finish.
So,
I will repeat my question.
With the witness, he must let the witness answer his question, because if he doesn't let him answer, then where else will he get the answer from?
please,
Yes.
can you comment? Yeah.
Can you comment, please?
What I wanted to say, Your Worship, is for the council to stop referring to the fact that I'm killing the case. Whether there is civil action to be undertaken by an aggrieved party, it still does not stop the same party to go and seek criminal action as well. Because if a person commits an offense today and we simply go and seek for civil recoveries, those people will continue doing it. So provided the elements of an offense are there, such can be reported. In fact, the two processes can be simultaneously done.
Very good. Before I finish on this contract, if you go to, I want you to go to page, Your Worship, I want the witness to go to page 57 of the same contract. I'm not going to read each clause, Your Worship. We've dealt with this one. I just want to confirm and agree with Mr. Inambawo. If you look at breach, you understand what is breach?
Yes.
Breach is when you don't comply with the contract. So the parties agreed what will happen in the event of non-compliance. In the event one of them does not comply. Are we together? If you look at clause 6, it goes up to should either party commit a yes, you do, you read, you go through it, and then it says the remedy that may have under law remedies. I want you to show me in this remedy where there is
What page are you?
57, Your Worship,
57.
clause 6, breach. Are we together?
Yes.
Yes. I want you to tell the court you have read this document before through your investigation. I want you to point out any sentence or clause or word where if one of them does not comply, if Enercon does not comply, where is it written that they must be arrested by ACC or prosecuted before a criminal court?
Must I read the...
No, you don't need to read. But I want you to show me if there is any provision for criminal prosecution in the event of breach or non-compliance. If you can't find it, then we move on. If you find it, you read it into the record, then we proceed.
although it's not talking about a criminal
No,
aspect.
just say there is nothing, Mr. In, about. There is no criminal prosecution.
No, but if I just stop,
He's just responding.
Yes, yes, Your Worship.
although there is no provision for legal, for criminal action, provided a conduct of criminal in nature was performed, such can still be reported, investigated, and if evidence is sufficient, perpetrators should be apprehended in this regards and dealt with in terms of the Criminal Procedure Act. I mean, one of the reasons why these pieces of laws are in this country is to prevent and deter people from committing the same offenses. Otherwise, people will continue cheating one another all the time.
You are not answering the question, Mr. Inamba. Are you saying these contracts were subject to the Criminal Procedure Act? Is it referring to it?
No. That's not what I said. I said even if it didn't make references to criminal action, provided a criminal conduct was undertaken and such is reported, it would be investigated, and if evidence supports prosecution, that is the reason why we are here.
Very good. Now, we saw you went through all the bank statement, Your Worship, that is B1 up to B9. We confirmed through all the applicants who testified. Who compiled those bank statements? Is it you? Enercon, NAMCOR bank statement, the bank account of Enercon 520, 848. You saw those bank statements.
That's correct.
You confirmed that on the 19th of July 2022, an amount of 35 million was paid by NAMCOR Trading to Enercon.
Can you just repeat?
You confirmed that on the 19th of July 2022, an amount of 35 million was paid by NAMCOR Trading into the account of Enercon Trading as part of the purchase price, correct?
Allegedly part of the purchase price, yes.
No,
correct.
but it was paid. It's clear. It's on the bank statement. It was paid. You can't say allegedly because it was paid.
I said allegedly for the purchase of the assets.
Okay. Now,
Do you confirm that?
Yes, I confirm the payment, Your Worship.
okay. And it was paid into whose account?
Enercon's account,
Yeah, Enercon's account.
ending the 35 million,
Yes,
ending with a 520.
very good. Now, when that money was paid as part of the contract, because we say when you sign a contract, in law we say, signer be aware, you are bound, you have to comply. NAMCOR is a good compliant, a good contractant said, we signed to pay, we must pay, and they paid. Now, after they paid the 35 million, that money becomes the property of Enercon. Am I wrong or right?
You are right.
Yes. Now, in terms of Article 16 of the Namibian Constitution, it talks about right to private property. You know it?
Yes.
Yes, you may not remember, but definitely you know about right to property.
Of course.
You have money in your account, you have your car, you field at the village. It's your private property. Our law provides for that. And Your Worship, I will argue for purpose of this bail application. Once you own something, when you have money, your phone, your car, that's what we call ownership. You agree with me? The right to ownership.
Provided what you are owning has been legally obtained, you are entitled to it.
Very good. And then the right to ownership, Your Worship, implies many things. You can use your property as you wish. Am I right?
Yes, if it's legally obtained,
Yes.
but not illegitimately.
Definitely, our submission is that the money was legally and contractually paid in terms of the valid contract. And now, our argument, Mr. Inambao, is that that purchase price, 35 million, when they received it, they paid it back to NAMCOR Trading as per the contract. Do you remember?
I hear you.
Yes. And then, the next payment, in order to complete the whole transaction, 18 million was paid again into the Enercon bank account, being 84.8. You agree with me?
I agree.
Yes. And then I will say the same theory applies. That 18 million became a property of Enercon. Any comment? Yes or no?
Mike, the money was proceeds which was acquired fraudulently from NAMCOR. And that is where it originated from. So the moment it was paid out, it was, that 35 million was used. Basically, NAMCOR paid Enercon's debt with own money, basically. Because although that money, there is this agreement, that money was used to pay the debt which Enercon had already incurred between March and July.
But where are you getting those things from? Did you get this from NAMCOR or it's your own interpretation? I will put it to you, Your Worship, the interpretation of contract or any document lies with the court, not with the witness, just to assist you. Okay? You don't need to interpret anything.
I was not interpreting. In fact, I was not done.
You can proceed.
Because the 18 million, as soon as the 18 million was paid to NAMCOR, to Enercon's account ending with a 848, we know a 9.5 was paid into Eco Trading's account.
No, please, Your Worship. No, Your Worship.
Your Worship, because the witness is not done answering, I think he should not argue with the witness. I've seen, I think it's continuing for few questions that the witness is interrupted, and as soon as the witness answers, before he concludes his answer, Then Mr. Bangamavo interrupts the witness. I think in all fairness, he must just allow the witness to finish his answers before he asks another question.
Yes, Counsel, just allow him. You can always make follow-up questions.
Yes, Your
Just
Worship.
allow. If he's not answering your question when he finished, then you draw his attention to
You
your
see the
question.
problem, Your Worship, you are dealing with the witness, he knows the answer, and he's trying to confuse everyone here.
But
But
let him finish.
Yes,
Give him the
Your Worship.
opportunity.
I will do
if
that.
he is not answering you, put
And
it
then
to
we will-
him.
then
That
we
is
will
not
argue.
my question. My question is this one,
I
so that he
understand, Your
can
Worship.
respond. Sir,
yeah.
you were not finished.
Yes, Your Worship. No,
Your
let me make it clear and short.
But he is not finished.
No, I think he's answered my question.
Okay.
Because my question was the 18 million when it was paid to Enercon 84.8, that money became a property of Enercon, yes or no?
No, because it was a proceed of an offense. So technically it was not theirs.
And, okay. Yeah, don't make me laugh. This is a serious issue. Now, I said when the 18 million was paid into the account of Enercon, whose money was that?
It was NAMCOR's money because it was a proceed. It's proceeds. Remember when you asked me about the money earlier, I said provided it's legitimately obtained. We know as soon as this money landed in that account, it started to be funded, to be distributed and laundered to other entities and individuals.
You see, that's what you don't understand, Mr. Inabao. Because in the law, once you are the owner of a property, you can do whatever you want with that property. If you have a car, you can even burn it. No one will take you to court for committing a crime. You know that. That's what we call use, utendi, and abutendi. The right to use and to abuse. So Enercon, I will argue, when they received the money from NAMCOR, it was their money and they were entitled as of right to do whatever they want with that money. What is your comment?
I've answered the question already, Your Worship.
We can move on.
Please, the court, Your Worship. Now, you say this was a vehicle of corruption and so on. If Mr. Nambanje took you through all the documents, the evaluation assets, the independent evaluation assets, memorandum by the fourth accused person, asset registrar, I'm sure you've seen those documents.
That's correct.
Did you have any problem or qualm with any of those documents which were prepared before the conclusion of the asset purchase agreement?
Those documents were used to satisfy the requirements in order to make this, subsequently to make the contract or the agreement look legitimate.
I see. But they were not legitimate. They looked legitimate according to you, but they were not legitimate. Is that your question?
That's
Your answer?
not what I said.
Okay, what did you say?
I said they were created. Remember the document which was authored by Ms. Dunaiski came before. In fact, all those documents came before the contract.
Yes.
So instead of just entering into a contract, because we are talking about a scheme here where the people had actually planned and organized to conduct a transaction. So meaning they had to make sure that these steps as far as the payment process are concerned are actually followed through.
Okay.
The evaluation is there, the feasibility study is there, and so forth and so on.
Still on the feasibility study, that was done by Shehema. You remember? Shehema. The financial project. Hashela.
That is Hashela, yes.
It's Hashela, Your Worship. Hashela, my colleague asked you about that document, you say no, you have no problem with that document, if I remember. Unless you want to contradict yourself again here.
I
I give you time to speak.
I didn't say I had a problem with it. I said these documents were created in order to make the contract later look legitimate. So Hashela was instructed to conduct a feasibility study, and he was given figures based on what the assessment went and determined, and asked to conduct a feasibility study. So for us to dismiss that the variables that he had put in there are incorrect, I am not in that position. But this was part of the requirement in order to make the contract later look like, yes, we have done the feasibility study, yes, we have determined the value of the asset, and this is how we concluded, or how we came to the price.
Mr. Inambawa, you have a big problem because you are speculating too much. Because you say you have no problem with the qualification of the person who conducted the study. That's what Namanje asked you. This was an employee of NAMCOR who in every day, that was his job. Why do you have a problem with that document? Why are you saying, no, it was made it to look legitimate? Can you answer? Can you make a comment on this?
I think you are not hearing me. I
Okay.
said these documents had to be in place. And I said I didn't have a problem with a document that was created by Mr. Hashela. Hence, I demonstrated as to how it happened. He was given the variables. He was given the amounts. And therefore, based on the amounts, he came up with the report. The report was used to justify as to the viability of the project, which subsequently was used to enter into a contract. And it's the contract or the agreement that is where the problem is.
Okay. Yeah. Of course, Your Worship, we all know how corporate entities operate, how executives operate. If you are an MD, you can't just make a decision without recommendation by subordinates. And in this case, we submit, Your Worship, Mulunga is the MD, Managing Director of NAMCOR Trading, could not make a decision without relying on recommendation, reports, and evaluation done by the appointed employees. And he had no doubt that they've done a very good job, and he made decision based on that. Any comment?
I'm glad that you are saying he could not make a decision without a feasibility study. And so was the agency. There was no agency of him not having followed all the other procedures which he should have followed in order for him to eventually go and buy the assets.
Which are those procedures?
The ones we were talking about, the procurement procedure, the financial and policy procedures, ensuring that he was operating within the budget. So there was no agency. He could have ensured that all these processes and procedures were followed.
You are shooting yourself in the feet. And I will say why, Your Worship. You investigated this matter. You had access to all those documents. Now, talking about the procurement procedure, where is that document you are talking about? Because that document, we don't know it. You have arrested someone saying he did not comply with the procurement procedure. Can you have, is there any reason why you did not provide that document to the state in order for the applicant to have a sight of that document? The procurement procedure, the one you are talking about.
I was not responsible for making a disclosure of the evidence that was disclosed to the Defense Council. But as far as the investigations is concerned, these are pieces of evidence that we collected. So in the docket that we have all these pieces of policies as well.
I see. But Mr. Inambao, you are objecting to the release of Mr. Mulunga and the other ex-employees on the basis that they committed a very serious crime. And you must demonstrate that these are serious crimes and they must not be released on bail. And you cannot do that until you rely on those documents. What is your comment?
In terms of the evidence that we have laid during the examination in chief, the charges are very serious, and we have proven how the scheme, was played from the point, the scheme, or rather the conspiracy, and how the offenses were played, how money was distributed, and so forth and so on. So these are serious offenses.
Yeah.
And looking at the values that are involved, looking at the nature of the charges, they are serious offenses.
Now, you say, let's for a while, let's pause the issue of serious charges and so on. You say, Mr. Mulunga, in, I think, your worship, that is count 1, exhibit D2, at page 1. Are you there?
Yes, I'm there.
Yes, I don't want to read everything, Your Worship. If you break down this charge, you are saying Mr. Mulunga corruptly used his office and position in a public body. Are we together?
We are together?
Yes. And you say NAMCOR. What do you mean by NAMCOR here?
Mr. Mulunga was the managing director of NAMCOR Trading, NAMCOR Holding and its subsidiaries.
Okay. Who concluded which party did he represent when the asset purchase agreement was concluded?
He represented NAMCOR Trading as the managing director
of the holding company.
Yes.
Just to assist you, being the National Petroleum Company.
That's correct.
Yes. Now, we will argue that actually NAMCOR, which does not receive any public funds from the government, and the ACC does not have jurisdiction to be involved in private entities' affairs and operations. What is your answer?
Your Worship, the operations of NAMCOR Trading cannot be divorced from the parent company, which is NAMCOR Holding, because it is there to further the interests of the holding company. Your Worship, although I cannot quote there was a decision which was made in
No. That's a question of law. We will deal with that. You are a witness. Witnesses don't testify on a question of law, Your Worship. Yeah, please. Otherwise, you get in a problem.
Okay, I will skip that one.
Yes.
But also, if you look at the mandate of the Anti-Corruption Act, the Anti-Corruption...
Because I think there is disruption here on the floor. I think if the witness were... I think he can be allowed to answer the question,
Yes,
because
he
was disrupted from answering the question in its entirety.
You can proceed.
He was not done.
This is the court, Your Worship. Yes.
Looking
Go
at
ahead.
the mandate,
Yes. The mandate. Carry on.
Yes, looking at the mandate of the Anti-Corruption Act, the mandate of the Anti-Corruption Act does not only stop with the public enterprises or public or the government. It is a piece of law which is there to maintain, to prevent corruption in Namibia, and as well as to investigate it, whether it's in private, whether it's in government. But of course,
Okay.
I will leave the other one. You said it's a question of the law, so the state will bring it up. So
Otherwise, we want to leave
Yes.
this place. Yes, Your Worship. Now, if I get you well, are you telling this court that the ACC mandate as per the Act legislation. You have a mandate to enter shabins, bars, and the metro, all the shops in the town, pick and pay, in order to investigate corruption. Any comment?
I mean, if somebody pays bribe, if somebody pays bribe and they come and report, it's still an offense. Otherwise, there's no way the country will come up with a law of the Anti-Corruption Commission, Act, and then we still allow private individuals out there to commit the same and only regulate it in the government. Then it's useless.
Mr. Nambao, that proposition is wrong. In the law, I will tell you the correct proposition, Your Worship. Corruption is defined in section 43 of the ACC Act. Let's go to that legislation. Your Worship, that is at page of the exhibit D2. That's exhibit by Namanje. If you look at 43, Your Worship, section 43 at page 59. One.
Say, are you there? Just give him a minute.
Yeah, please give him 59, Mr. Inambao. It's a exhibit D2. Can the state ensure that you are there?
I'm almost there.
D2 at page.
Yes, I'm there.
Yes. 431. Are you there?
Yes, I'm there.
Okay. It says a public officer commits an offense who directly or indirectly corruptly uses his or her office or position in a public body to, are you together?
Yes,
to
we are
obtain
together.
any gratification. And then 2, for purpose of subsection 1, proof that a public officer in a public body has made a decision or taken into any matter in which the public officer or any relative and so on. It goes on. Now, when you say you can enter shabins and the shops, are these public office? Are you targeting public officers in those shops?
Your Worship, if you look at section 3, which is the functions of the of the commission, specifically if you look at section 3E, you would see that it does provide mandate for both. Are you there?
I'm there, I'm listening, Mr. Inambao.
Page 37.
37. Which section?
Section, is it D? Is it the same act we were reading?
Definitions or
Yes.
functions.
The functions of the
Yes.
commission. If you look at E,
Yes.
it says one of the mandates of or rather the function is to investigate any conduct of a person employed by a public body or a private body which, in the opinion of the commission, may be connected with or conducive to a corrupt practice, and to report thereon to an appropriate authority within the public body or the private body.
Yes.
So section 43 is an offense in chapter 4.
Yes.
So meaning, as far as the act itself is concerned, we are also able to regulate some of the conducts, not necessarily charging a private person on section 43.
Because it says, or private body which in the opinion of the commission may be connected, are you together, with or conducive to a corrupt practices. Are we together? Yes.
That's what he just read.
Yes. Now, when Mr. Mulunga testified, I'm sure you were watching on YouTube, or maybe a state council told you. When Mulunga testified, he says NAMCOR Trading and Distribution Pty Limited, it's a separate entity, juristic entity, and the shareholder is National Petroleum Company. But we know in terms of the law, shareholders are separate from private companies. Do you agree with me?
Your Worship, during the investigations, we were able to obtain the documents of association for both NAMCOR Holding and as well as NAMCOR Trading.
Yes.
So indeed, they are separate, and hence we are saying NAMCOR Trading's functions is basically carrying out its parent company's function, basically furthering the interests of its parent company. As far as the legal question that you were saying, the state will argue it.
Okay.
So I'll not be able to tell you that, but at least I've given you an answer.
Yes. The evidence of Mr. Mulunga was corroborated by Jennifer Hamukwaya when she testified as the former chief finance and administration for both companies. She told the court that actually NAMCOR Trading and Distribution Company does not receive a cent from NAMCOR Petroleum Company. It does not receive a single cent from the government, from the fiscus. Any comment to that?
Your Worship, at some point, NAMCOR Holding and as well as the trading was receiving fuel levy. If I'm not mistaken, they most probably are still receiving it. So, but I'm not going to argue it. And I'm saying they were receiving levies. But as I was saying that the government, the prosecutor will argue the question of, whether it's a public body or not. So I'm not going to get in that now.
No. Jennifer Hamukwaya, who worked for more than 10 years at NAMCOR National Petroleum, she said only NAMCOR National Petroleum Company received the levies, not trading and distribution.
I don't have a comment for you right
Yes.
now. I'll leave it there.
Okay? Now, relating to that question, we say the National Trading is a private company which concluded an agreement with the Enercon, another private company. Are we together, Mr. Inambawa?
We are together.
Yes. The money paid was never received from government. It was never received from the National Petroleum Company, and therefore does not constitute public funds. Any comment?
NAMCOR Trading's principal business is to pursue the interests of NAMCOR Holding, which is an entity owned by the government. A lot of your questions I'll not be able to answer them because of the judgment that I wanted to refer to, because that judgment does make provisions as far as the subsidiaries which are owned by public enterprises.
You see, if you go there, I don't want to argue with you because you are not a lawyer.
Yes, that's what I'm saying. So a lot of the questions you are asking me, they will be answered by that very judgment.
Yeah, but I asked a specific question, Your Worship.
Yes, but are you finished?
I'm
on
finished, Your
answering?
Worship.
Okay, then we can move on.
No, Your Worship, I asked. The money which was paid by NAMCOR Trading and Distribution to Enercon cannot constitute public funds because the evidence on record shows that NAMCOR Trading never received a cent from government, not a cent from National Petroleum Company. Yes or no?
I don't think I entirely agree with you because at some point, these
Half
institutions...
agree, half disagree.
Yeah. Let me not answer that one, Your Worship.
Okay.
We can proceed.
Please, the court, Your Worship. And then On behalf of Mr. Mulunga and Jennifer Hamukwaya, fourth and fifth applicant, we argue that actually ACC or the Anti-Corruption Commission, by getting involved in this matter, is acting ultra vires the governing legislation. What is any ultra vires meaning beyond its power? What is your comment?
Your Worship, ACC is within its mandate and functions, and hence this investigation is being conducted. So we haven't gone beyond our mandates. There are charges under the Anti-Corruption Act. There are charges of money laundering and as well as fraud. And the evidence is established. We have a strong case.
Okay. No, no one has laid evidence yet. This bail application, Mr. Inambao, no evidence is before court yet.
One of the requirements was that we provide evidence, which I did, in order to show the strength of the state's case.
No, otherwise it won't work because you are relying to other people who are not here. Let's not go there, Your Worship. Now,
Can we move on?
yes, Your Worship. Mr. Inambao, if you look at the charges against Mulunga, you say he exceeded authority, but you charge him for not having a board approval to sign. But I referred you to clause 4.2 of the schedule of authority, which allowed him to sign any agreement with any amount. Why did you charge him in respect of that allegation? Do you still stand with that allegation after looking at 4.2 of schedule of authority? Do you want to withdraw it or you still want to maintain it?
Perhaps you can refer me to the charge.
Okay,
before
yeah. The charge I'm referring, it's a number, Your Worship. It's fraud, count 2, fraud. Number, page 1. You say, this is in respect of Mr. Mulunga, during the period of 2022-2023 at near Windhoek, falsely and with intent, and pretended to NAMCOR. We don't know which NAMCOR you are talking about. We don't know if it's National Petroleum or Trading, but you say, as a managing, he pretended that he had authority to make an offer and acquisition of 9 service stations. That's number 1. Why do you say he pretended he had an authority when he did not have authority? Are you still saying Mr. Mulunga did not have authority to sign the asset purchase agreement? After I've referred you to clause 4.2 of the schedule of authority.
As indicated previously, by virtue of his position, he had the authority to sign, provided the procedures were followed. And in this regards, the procedures were not followed. Hence, NAMCOR reported a case.
Yeah, when we are there, you keep on saying NAMCOR reported the case. Ms. Inambao is an experienced investigator. People complain every day, but you have to do your job and investigate. And you must be, after looking at schedule of authority yourself, you should tell NAMCOR, why are you trying to use me to fight Mulunga? Because he had authority to do what he did. Don't you have enough strength to tell them that?
That is why there's also charges of abuse of office and position for gratification. It's because of the authority that he had, which he abused. So, in order for an investigation to graduate from a complaint that was received until a perpetrator is apprehended, it means a lot of efforts should have been undertaken. It means there was sufficient grounds to prove that an offense was committed in this regards, before a suspect is apprehended. And our investigations has gotten to the point where that evidence was sufficient, or we had sufficient grounds to believe that indeed Mr. Mulunga had committed these offenses.
Okay. Your Worship. Now, I will argue on behalf of Mr. Mulunga that he had authority in terms of schedule of authority, and therefore the charges against him are baseless, meritless, and actually we can move for an order in terms of which Mr. Mulunga can be released on warning until the state withdraws its charges. What is your comment?
I am here to oppose bail. That's why the state called me, because in terms of the evidence, there is sufficient evidence indicating that Mr. Mulunga and all the others have committed serious offenses. But it's not my duty to make that determination. I'm simply here to paint the picture.
There is no evidence before court yet, Mr. Inambao. Now, let's go to charge. I'm not going to deal with alternative charge. Let's go to counter 3, Your Worship. That's page 2. Yeah, Your Worship, counter 3. Are we together, Mr. Inambao?
We are together.
This is the famous car. The one you are brandishing, that it's gratification. Yeah. You say between 15 and the 18 August 2022. Are we together? Underline August 2022.
Yes.
Near Windhoek, in the accused being an agent of NAMCOR, managing the corruptly accepted from Simaneka Malima, the shareholder of Eco Trading, a motor vehicle, Audi 65XQ8. You put the engine numbers and so on, the value, and Your Worship, as a reward for the accused as the managing director of NAMCOR to facilitate the purchase of 9 service stations. Are we together?
We are together.
You say you are here to oppose bail. What is this, Mr. Inambao? What are you talking about? Did you, whoever drafted this, did it come from you? I'm laughing, but this is serious. Because I will tell you, you told the court, Your Worship, you investigated the issue of the car. You remember? You said you went to Natis.
Can just allow him.
Yes, sorry, Your Worship.
It appears you put a question, did this charge come from him?
Yes, Your Worship.
Yes.
Yeah.
Any comment?
Your Worship, we conducted investigations. We provided the investigations to the evidence to the prosecution, so that proper charges are.
Came from you.
The evidence came from us.
Yes, from you, because you are the main chief.
Yes.
Yes.
I provided the state with the evidence.
You are a confident man. Stand by your word. Don't say us. Say you. I. Okay. Now, when you testified, you told his worship that the car was bought when? Do you remember? Do you remember yesterday?
Yes.
In evidence in the chief. When
Yes,
was the car allegedly bought?
Was bought in 2023.
2023.
Yes.
So what do we have here now? Check. There is no mention of 2023 in count 3.
Yes, as I indicated yesterday, an error could have occurred with the dates because of the amount of time that was there, when the charges was formulated.
But how do we prepare for this, Mr. Inambao? Because you are opposing bail and you want to show to the court that the allegations are wrong, they are meritless. But you keep on saying you amend.
There are preliminary charges. And I'm sure your client has not been asked to plea on the charges. So, but we have very strong evidence indicating that the vehicle existed and Mr. Mulunga was in possession of it.
You see, okay. Now, we are there. You say, okay, it's a typing error, okay. Now, you say, this car was accepted
from Malima, a shareholder of Eco Trading. Are we together, Your Worship? Are you there? Eco Trading.
Okay, still getting there.
Yes.
Eco Trading CC?
Yes. And then you say, because to facilitate the purchase of 9 service station, are you following?
Yes.
The last sentence.
Yes.
Now, Mr. Inambao, if was Eco Trading CC a party to asset purchase agreement? Who were they were, if I remember, Mr. Inambao,
Yes.
the only parties was NAMCOR Trading and the Enercon Pty Limited.
Yes.
Do you remember?
Yes. But
Do you agree with me that Eco Trading CC was not a party to
Yes.
asset purchase agreement?
although Eco Trading CC was not a party to the asset purchase agreement, Mr. Simaneka was was the denominator in most of the transactions. We know that out of the 18 million that Enercon received, 9.5 million went to Eco Trading.
Inambao, I asked. Honestly, Your Worship, I asked. Was the Eco Trading CC a contracting party to the asset purchase agreement? The answer is yes or no. Then we move on.
I've answered it, it's only that I quantified it.
What is the answer again? Yes or no?
I said yes, I said no,
Yes.
but we know that Eco Trading received, out of the 18 million, Eco Trading received 9.5 million.
But do you agree with me, Mr. Inambao, Your Worship? This charge, counter 3, doesn't make sense. Because how would you give gratification for things you are not party to? Eco Trading was not a party to that contract. And you keep on saying it was a vehicle, instrument, all sorts of names. But this Victor Manema, it does not even appear as a director of Enercon in July 2022. Any comment?
As indicated previously, although Eco Trading was not party to the agreement, the distribution of the funds that was received in Enercon came out or was made from Eco Trading.
Okay, I think I got your answer, Mr. Now, you told the court that in your investigation, very serious and deep investigation, you went to Natis. You remember?
That's correct.
What did you get from Natis? What was the outcome of your investigation at Natis?
Your Worship, as the vehicle was registered under Mr. Mulunga's cousin.
No.
His name.
Say the name of the owner of the car.
Yes, Hileni Kamati.
Yes. Why are you scared to say that?
No, I'm not scared.
Yes. Now, where is the proof of what we call certificate of showing the owner of the car? Why is it not before court? Why you went there, you saw it, but you didn't want to give it to the state? Is there any reason behind the holding of that certificate of registration?
I'm sure if the defense wanted a copy, we could have made arrangements for the defense to have the copy disclosed.
Is there any reason why you submitted all bank statements relating to transaction and the other document, but you decide to keep that certificate?
As you said that it's not during the trial, so there is a lot of pieces of evidence that the state has not disclosed. But in terms of the investigations, the amount of evidence we have is quite a lot, and I believe what was disclosed, it was just for the purpose of
I put to you that the reason is simple, is because you want to hide the truth from the court, to show the truth being that Mr. Mulunga never owned that motor vehicle in question.
There was no point where we indicated the vehicle was registered on Mr. Mulunga's name.
How do you prove ownership of a motor vehicle from your policing perspective?
This vehicle was disguised.
And then, still on the motor vehicle, you went to the bank to investigate the motor vehicle. You remember?
That's correct.
Now, what did you get from the bank?
The vehicle was financed by Mr. Simaneka.
Financed?
Yes.
Was
A
it
hire purchase?
Okay, or hire purchase?
Yes.
Okay.
Where I believe there was a deposit of a little over 900,000, which was very interesting for this vehicle to be in possession of Mr. Mulunga.
Yeah. When was the 900 paid? Deposit?
I'm not in possession of the account statement right now, but it was paid before the vehicle was collected.
No. Just the year.
2023.
2023.
That's right.
Do you remember when Mulunga left NAMCOR? Do you still remember
I
when?
believe he was suspended by April 2023.
April 2023.
Yes.
And the vehicle in August 2023.
Yes.
Okay. Now, do you have a copy of the HP, the hire purchase?
That's right.
Where is it? How come no one, even the state doesn't have that document?
As I was saying, some of the documents, the state was disclosing them on the request, but we do have it, and it can be made available should the court desire to see the hire purchase. That
No,
can
not
be
now, Mr. Inambao. At least the applicant ought to have sight of that document to comment on it, not now.
Sure.
Please, the court, your worship. Now, according to your understanding of hire purchase agreement, who is the owner of the subject matter of the hire purchase agreement?
It's Mr. Malima.
You see now, Mr. Inambao. That's why I said you need the legal department in the ACC. I put it to you that, your worship, the owner of the motor vehicle, any property subject to hire purchase, is the financier, the bank, until the final instrument is paid. Do you agree or not?
No, I think I may have misunderstood. As far as the person that went to sign for the hire purchase is Mr. Malima, and that's what I meant.
Okay.
So the vehicle remains the asset of the bank until the final installment is paid. So that account is in the name of Mr. Malima. And when I was answering, that's what I was answering on.
And now, is the car fully paid?
No.
No. Because I'm saying this because you were making the big story, we are denying bail to Mr. Mulunga because he's hiding the car. But we know the car is not his. Why don't you go and check at the bank? Maybe the bank is having the car. Or Mr. Marimba took it. Or Mrs. Kamati Elindi took it. Why Mr. Mulunga is just a scapegoat? Do you know what is a scapegoat? Is a victim of witch hunt.
Can you just
What
make
is
your
the comment?
questions short?
Okay, sorry, Your Worship. I put to you that Mr. Mulunga is a victim of witch hunt and he has nothing to do with the car. The only crime he committed is to drive the car, but there is no evidence before court that he knew anything about how the car was bought. What is your comment?
Your Worship, I did not know Mr. Mulunga, other than seeing his picture maybe on the newspapers here and there. The first time I met with Mr. Mulunga is the very day that we arrested him. So, and therefore, I dismiss, the claim of Mr. that the council is making that is a witch hunt. As far as investigations is concerned, the evidence is concerned, Mr. Mulunga was using this vehicle. It was in his possession. As far as the trail is concerned, Your Worship, you know, the registration, it was part of disguising, you know, the proceeds of offenses.
Now, let's go to the next count, count 4, Your Worship. You say, again, you are accusing him, together with Jennifer, Willemse, and the Panduleni, and so many other people, that he must be arrested and kept in custody because he concluded the contract involving 9 service stations. Do you still stand with that charge, Mr. Inambao? Because you concluded that, you agree that he had authority to do what he did. Do you still stand with this charge? Count 4.
Count 4.
Yes.
Section 45.
Yes.
Dealing, using. Definitely, definitely. That's why I'm here, is to make sure that we stand by the charges. That, definitely.
And then you receive, he said he received the gratification and he created the gratification for others. Which gratification did Mulunga receive? After signing or before signing the asset purchase agreement?
You see, the beauty about gratification, Your Worship, is...
No, I'm asking you which gratification.
And
I know it.
I'm answering...
Answering your question.
Yes.
Please, the court, Your Worship.
The gratification doesn't carry an ordinary meaning. Meaning, you don't have to receive the gratification yourself. The gratification can be for another person. So in this regards, even if we are unable to prove that Mr. Mulunga, for example, received a part of this 53 million, we can prove that the gratification was created for Enercon. We can prove that the gratification was created for other individuals who were role players in this.
Yeah, I think we have a big problem. Yeah, okay. Let's move to count 5. Again, you say the accused wrongfully and unlawfully. You said you considered that Mulunga never received the gratification. You say he created for others. Let's move to 5.
The vehicle is one of the ones that you...
I think I'm done with the vehicle.
Yes.
Yeah, please. I don't want to take hostage of the Honorable Court. And then you say wrongfully and lawfully conspired with the fellow staff members. Now, you are creating a dispute between Mr. Mulunga as the former managing director and the subordinates. He conspired. During your investigation, did you find anything to the effect that Mulunga commanded and ordered and conspired with the ex-employees of NAMCOR in order to commit offense? Any evidence? Why is that evidence not before court?
We have demonstrated that during my examination in chief, especially when we are talking about the conspiracy. From the point when Enercon's relationship started with NAMCOR, to the point when the cession of EcoFuel was ceded to Enercon, to the point when the agreement was entered into on the 16th of March 2022, and subsequent to that, the asset purchase agreement was entered to on the 18th of July 2022, which resulted in some of the money that was paid into the staff members' accounts or related accounts.
You keep on repeating yourself. I said, was there any evidence which you uncovered where Mr. Mulunga had a secret meeting or commanded, and because he testified and he told the court, Your Worship, there was no complaint whatsoever from any of my ex-employees that I coerced them to do anything unlawful. He told the court that.
It's because they conspired, and hence the charge. It's because they planned.
Okay. Now, Your Worship, 6, it's again the motor vehicle. You are referring to agreements. There was an agreement between Simaneka and Mr. Mulunga. Do you have a copy of that agreement where he agreed to buy the car for Mr. Mulunga? Can you have a copy of that agreement? Charge 6 at page 3. You say unlawfully commit money laundering by indirectly entering into an agreement with the Simaneka. Do you have a copy of that agreement, or you call Mr. Simaneka to come and confirm that agreement?
We don't have an agreement, but the fact that Mr. Simaneka had given the vehicle to Mr. Mulunga, definitely there should have been some sort of an arrangement or an agreement between them.
Mr. Inambao, Mr. Mulunga told the court the only arrangement he had with Mr. Malima was to take his vehicle for service, and he drove it for some time. That's the only arrangement Mulunga knows of. Any comment?
That also is part of the evidence, which is very good, because he's actually, partly confirming that there was an agreement for him to use the car for some times.
Now, are you telling me, Mr. Inambao, if you find me driving someone's car in town, did you see him driving that car?
Yes.
It's part of your investigation.
Part of my investigations, myself and another colleague physically saw Mr. Mulunga driving that car.
Okay.
And hence the,
Yeah, carry on. Sorry, I don't know.
No, I'll stop there.
Yeah. Yeah, you stop there.
Yes.
Okay. So I wanted to ask just a rhetoric question. If I have a friend or a business colleague, I know you, I know Caspar, I drive his car, I take the car for service, I don't know where he got the car from, maybe he stole the car. Do I get arrested for that and prosecuted for that and kept in custody for that? Any comment?
Every case is dealt on its own merits. In this regards, there were some criminal activities that had happened or that had transpired between NAMCOR and Enercon, to which some of the money went to the previous owner of EcoFuel, or rather the owner of EcoFuel and the owner of Eco Trading, of which Mr. Mulunga was, in the middle of all this. So, and hence I'm saying, it depends. So in this regards, each case, it's dealt on its own merits. So in this regards, there was some criminal activities that has been occurring between Simaneka and Mr. Mulunga. It makes it a different thing.
But you are mixing up things and creating stories. I put to you, was Simaneka Malima representing Eco Trading? Was he part of the asset? You said the asset purchase was a vehicle for criminal activity. And I asked you, was Malima part of that transaction? And the answer was no.
Yes.
Was Eco Trading part of that contract? You say no. So I don't know where you are getting all
When
this.
you look at it in isolation, if you only look at it from the point of the asset purchase agreement, hence we started with the conspiracy, which started already in 2021. If you look at the 2nd of March, 2022, the debt, 73 million, was ceded from EcoFuel, which is owned by Simaneka, to Enercon. So, and hence we are saying already that conspiracy, already that relationship started long. So the vehicles is just the products, it's just the rewards for the relationship.
Yeah, but we demonstrate to the court that the car is not in his name. He is not the owner.
Your worship, is what people who are busy committing crimes of money laundering are busy doing. They are hiding and disguising these assets in other people's names.
Now, when we are there, because it's very easy to make a blanket statement but the court does not concern itself with blanket statement. He who alleges must prove. I'm sure as a police officer you know that. Now, you told the court you met with the Heleni Kamati. Is it Helena or Heleni? Heleni.
Yeah.
I know one of my colleagues here, her name is Heleni. Heleni Kamati. Now, did you meet Heleni Kamati?
That's correct.
Okay. Did you make any statement from Heleni Kamati?
That's correct.
Where is that statement? The state does not have that statement. The applicant has no that statement. You are only raising it now during cross-examination. Is there any reason behind that?
Your Worship, as far as the current process is concerned, I don't think the state had disclosed the statements that has been obtained during the investigations. I believe that was not part of the process. So the state has not disclosed any statements.
Oh. But Nambao, you told the court that's how people commit corruption, money laundering, they hide properties in other people's names. I think that statement will be very crucial as far as the state case is concerned. I can't believe you did not produce that statement. Like my colleague says, you are a danger to the state case. What is your comment?
I have no comment to your statement right now. I think I'm just going to ask you to refrain from saying that I'm a danger to our case because we have laid the foundation as far as our case is concerned.
Please, go to your worship. I think that is for Mulunga's charges. Let's move to, okay, why I'm still with the Mulunga. When you went to arrest him, and this was raised by...
Just give me a minute.
Okay, my your worship.
You can proceed.
Please go to your worship. When Mr. Namanje asked you, why do you, is there any policy within ACC when you are arresting people or the so-called high-profile suspect? Is there any policy allowing you to go with the cameras and media at their private residence?
Mr. Bangamabwa, you heard my answer yesterday. And
Which
I don't think you want me to repeat it.
I know you must repeat it. You have to repeat it.
You know, today I would say, like yesterday, I wish we had actually invited the media inside so they can record the whole process as we were explaining the charges to Mr. Mulunga. It would have been much better.
Okay.
Yes, just answer the question.
Answer the question. Do you have a policy at the ACC which allows you to go and arrest the so-called big fish with the media and the cameras? Yes or no? Please.
There's no policy, Your Worship, and we didn't go there with the media and cameras. So, Your Worship, if my memory serves me correct, if no one took a picture of Mr. Mulunga because we had made sure that we reversed the car into the garage and he got into the car. So the only thing that was even on the social media was the vehicle, not Mr. Mulunga's picture. So in that regard, we really tried from our side to make sure that this was done in the most humane manner, in the most respectful manner. Under the circumstances, the people were there and we had to do what we could do under the circumstances.
Who leaked the information that Mr. Mulunga was going to be arrested on that particular day, on that particular hour and minute?
I have no idea, Your Worship.
Did you try to ask the media who were there how they come to know that you are arresting Mr. Mulunga?
I have no idea. I didn't ask them. In fact, I asked them to move away because at the time we got there, I spoke to Mr. Mulunga on the phone and he said he was not at home. So I did not needed any people there to make Mr. Mulunga run away. You know, we wanted to do it in the most, I don't know what else to say, but.
Now, our colleague was dealing with the first and the second applicant. You told the court you have no objection in the event that the court makes a decision to grant bail to Mr. Mulunga. Would you have a problem if he reports to you at ACC like first and second applicant?
First, I'm here to oppose bail. So, in the event the court decides that, I'm not to determine the conditions. I'm here to come and place the state's records opposing bail because of the seriousness of the offense.
No, of course you can't make a decision.
Yes.
You are just an investigator.
Of
Only
course.
the magistrate, the presiding officer, his worship will make a decision.
Of course.
But I'm repeating the question. Yesterday, Namanje asked you, if they were to be reporting, would you accept that they report to ACC or any police station?
I will not comment on any of the bail issues. All I will say is the state, I'm here as a witness for the state. The state is opposing bail, and that's my response.
But Mr. Inambao, yesterday, are you now retracting what you said yesterday?
If I've said it yesterday, definitely I'm retracting it.
Oh, I like that
Yes.
one. Yeah. The court will argue that you are not a credible witness, and actually, because of your contradictory evidence, the court will be invited to ignore and disregard your evidence. What is your comment?
We have provided the evidence. It's the duty of the court to make a decision as to whether the bail will be granted or not.
Now,
We have said evidence has proven crimes happened of a serious nature.
it's allegation, Mr. Inambao, no crime. It's allegation. Please, you know it.
Yeah. You are not expecting me to comment, right?
No, I'm very baffled by you as an officer, as a witness, who is supposed to be impartial and independent, who has a duty towards the court. After you have made a statement in this court, you say you are withdrawing, you are retracting. And unfortunately, it's too late. The bus has left. You can't retract it.
That's what you are saying.
Because if you do it, it means you are applying what we call selective justice. If you are doing that, first and second applicant can report to ACC. If the court grants bail, where do you want Mulunga to report?
I haven't agreed to it. I've just said, if I said yes or no yesterday, that was yesterday, but my position is the same when it comes to all the accused persons.
Okay.
We are here to determine whether the accused person should be granted bail. The state has called me to come and object to that position because of the nature and the seriousness of the offense. So it will be the duty of the court.
Yeah, not you. You can't determine bail. Yeah. Yeah, you have to try to be careful with the words. Okay? Yeah, only the court, even myself, I can't determine bail on okay? Yeah, now, I put to you that, tell me, before you arrested Mr. Mulunga, he told the court he has been aware of the ACC investigation for some time, dating back to 2024. He told the court, 23, 24. But despite the fact that he knew about the investigation, he said, I'm not going anywhere. This is my home country. I have no foreign ties. I'm ready to stand trial and clear my name. And therefore, he's not a flight risk. Any comment?
Which could be the reason, Your Worship, why he interfered with the investigations in terms of the vehicle that he was in possession of?
We are talking about flight risk, not investigation.
It's because, Your Worship, I believe all the accused persons believed it was a commercial transaction.
But Mr. Inambao, the court is listening, is taking notes. What are you trying to do now? Because I asked him, this man was aware of the investigation from 2024. He never left the country. Do you have evidence that he tried to run away from Namibia? Tell the court.
I've answered it. I've answered it. I said, I believe all the accused person believe this was a commercial transactions. They didn't think it would get to this point.
Okay, you don't want to answer that question. Because when he said that, Your Worship, the State Council never challenged that evidence during cross-examination. He never put that version to Mr. Mulunga.
I was not the one prosecuting, or I was not the State Council, and you asked me a question, and
I'm telling you what to happen, Mr. Nyambali. To be fair to you, I'm telling you what to happen. And then we continue. Mr. Mulunga said he has 10 dependents, of whom 8 are depending on him. And if he is to be kept in custody, those people will suffer immense prejudice. And because of that, he is a good candidate for bail. Any comment?
no comment.
Okay. Mr. Mulunga said he is prepared to pay 10,000 if the court is satisfied that he is a good candidate for bail. 10,000 in the amount of bail. Any comment?
Your Worship, we are not looking at the prospects of bail. So if I were to agree or disagree on the bail amount, it will be injustice.
You can say no, yes.
It would be injustice to the position of the state.
Okay. Mr. Mulunga says he is presumed innocent until proven guilty by a competent court, not by investigators, not by ACC, a competent and independent court. And because of that presumption of innocence, Mr. Mulunga says granting him bail will be consonant with the presumption of innocence. Any comment?
Your Worship, it is a serious, there are serious offenses that Mr. Mulunga is facing. We have very good evidence, and we have a strong case against Mulunga.
We have shown that there is no state case. The state case is fallen flat on the floor. There is nothing. You confirm that he had authority to do what he did. Now we are saying there is a strong case. Now, Your Worship, it's now almost 1. I'm done with the Mr. Mulunga. I want to touch on Jennifer, and then I'm done. Can I continue now, or can we break maybe for?
Yeah, then we can, because you are not going to finish now.
No. Now I need 20 minutes for Jennifer Hamukwaya.
Okay, then we can pack it.
You can pack it for
Yes.
2 minutes. Please, go to Your Worship. No, for 10 minutes. 10 minutes.
No, we are adjourning. Yes.
We are June Monday.
Yes.
Yes, another matter.
Okay, no, that's in order. Your
That's in
Worship.
order.
Yeah. I don't want to prejudice the client's
Okay.
case. Please, go to Your Worship.
Just before we adjourn, Your Worship, I just want to indicate that on Monday I have another matter, an appeal in the High Court that I want to attend to. I wouldn't prefer that my colleague Ms. Hinda comes, because I would want to listen to the cross-examination so that I can argue the matter. So I'm proposing that we at least start at 10. I do not think the appeal will take that long that I have on Monday.
Councils?
There is in order, Your Worship.
Yes, Your Worship.
We have to accommodate.
No objection to that suggestion, Your Worship. May we then please keep it strictly at 10, so that we can get somewhere with this.
Yes, but then council
application.
must communicate with, yeah,
We will do that, Your Worship.
okay.
That's in order.
Say you are still under oath. The matter is then postponed to Monday. Let me just confirm the date on Monday. The 11th of August. Applicants and accused, you are in custody until then.
Your Worship, may the witness be admonished
Yes.
that he is under oath,
Yes, I have informed him that
and he
is
should
under
not discuss this matter, not even with his wife or his colleagues, Your Worship,
oath. Yes, he is
in
under
light
oath.
of these retractions that we are now also seeing in court.
Sir, you are under oath. Do
Thank you,
you
Your Worship.
understand? Yes.
Hearing the witness having discussions with his
During the
colleagues, we
breaks.
just want that to be placed on
With
record,
what?
Your Worship.
His colleagues.
With his colleagues, which he's not allowed to do.
The court adjourns.